It's clear as we come together today that too many Americans go to too many prisons for far too long and for no truly good law enforcement reason. It's clear that at a very basic level, the 20th century criminal justice solutions are not adequate to overcome our 21st century challenges. And again, it is well past time to implement common sense changes that will foster safer communities from coast to coast.
All right, ladies and gentlemen, welcome back to the Steve Malzberg Show. That was Attorney General Eric Holder earlier today announcing that the Justice Department will no longer pursue certain mandatory minimum sentences when it comes to certain drug offenses. Joining us now is Judge Mukasey, who, of course, was Michael Mukasey, who was, of course, the Attorney General of the United States under George W. Bush. Judge, good to talk to you again, sir.
Good to be with you.
All right. So you heard Attorney General Holder talk about basically some of his thoughts about our criminal justice system. He went on to say that the criminal justice system is broken and cited that 1/4 of the world's prison population, or just about, is here in the United States of America. Talk about what you think of his declaration today.
Well, it's interesting, not particularly logical, but interesting. The proportion of people imprisoned in the United States is absolutely no indication of whether we're doing too much or too little. I think that if there are sensible proposals to be made for diminishing the amount of incarceration, I'm all for them. If there are sensible proposals to be made for eliminating mandatory minimums, I'm all for that. But saying that you're not going to enforce the law isn't the way to do it.
Well, I couldn't agree with you more. Of course, and I want to get back to this, but this is just kind of the latest. You have President Obama delaying the employer mandate portion of Obamacare. You've had the immigration law altered by the Obama administration deciding what to go after and who to go after and who not to go after, and which part of the laws to enforce and which not. The requirement for work in the welfare reform bill, the president changed that a bit as well. And then there were the recess appointments, which at least 2 courts, I think 3, have found to be unconstitutional. Do you see a pattern here?
Well, it's hard not to. In this case, not only have they chosen to disregard the mandatory minimum statutes and said essentially that even if somebody is caught with an amount of drugs that would trigger the mandatory minimum, we're going to hide that. We're not going to include it in the charge. We're going to keep that from the court and file a charge only of a lesser amount, which I think is a violation of the law. But Congress passed a statute that talked about the circumstances in which the mandatory minimum would not apply. It listed certain criteria at the time of sentence, and it said that if a defendant meets those criteria at the time of sentence, including that he has disclosed everything about the circumstances of the crime to the prosecutor, then the judge does not have to impose what would otherwise be a mandatory minimum. What he's saying is that we're going to make that decision at the time that a charge is filed, when, of course, very little is known about a defendant compared to what could be learned later on, and a defendant will have absolutely no incentive to disclose all the circumstances of the crime because there's no leverage on it.
Right. Two very interesting things that come out of what you just said. So in an attempt to, or as stated by Attorney General Holder, that low-level drug offenders who are not involved in gangs, not involved in high-class selling or major selling of drugs, et cetera, we want to keep them out of prison. But you're saying that you may not know all the facts and may not know all the involvement because you're giving them this break.
Well, you're not going to know them certainly at the time that they are first picked up,
right? Which
is when the charging decision is made. The sentencing decision is made after facts have been learned, after a defendant has pleaded guilty, after a defendant has disclosed all that he knows, and the prosecutor has had an opportunity to check on it if he wants to take that opportunity, and then the sentencing judge can go outside the mandatory minimum. But doing it this way, I think, diminishes the incentive for getting any information at all, in addition to being a violation of the law.
And you also, that's what I wanted to pick up on. You also said it's a violation of the law. So you're saying that that if in fact Eric Holder goes through with this and the Justice Department goes through with this and this is the new policy, that this in fact will be a violation of U.S. law?
Yes, sir. Congress passed statute, whether wisely or unwisely, is not for him to decide. imposing mandatory minimums on certain levels of drug trafficking. And if we want to get rid of those, then the way to do it is to pass another law getting rid of them, or to do what Congress did, which is to pass a statute that says that they don't apply in certain cases. But what he's saying is, I'm not even going to apply that. I'm going to have us make that decision at the time a charge is initially filed.
Is this analogous to the other instances of enforcing the parts of laws you want to enforce and not enforcing, and or is this? Do you think that this stands above the rest, and is this kind of unprecedented in your view?
Well, it's precedented only to the extent that they've done it in the other situations that you mentioned. I don't know of any other situation in which an administration has repeatedly said we're going to enforce the laws and uphold the laws that we agree with, and we're going to disregard the rest.
We're talking to Judge Michael Mukasey, former U.S. Attorney General, of course, here on the Steve Malzberg Show. Always great to have him with us. Is there any, could any party now go forward and try to stop this by going to the courts and saying that this is a violation of current law?
Well, I guess it's conceivable that, there'd be a question of who has standing to do it. I guess it's conceivable that members of Congress could sue. But that's not something I've looked into. And in any event, I think that most people believe that mandatory minimums should be either diminished or gotten rid of. But as I said, the way to do that is to pass a law, not to do it this way.
Right. Now, you've said that. Why do you believe that that mandatory minimum should be done away with, sir?
Because I think that they needlessly handcuff judges, and these were meant to get around situations where judges were imposing sentences that some legislators thought were too lenient. And so what they said was, well, we're going to make the minimum mandatory so that the judge has no choice. But I think that is a misperception, and allowing the government to appeal some sentences is the solution to that without imposing a mandatory minimum. I had a case involving a mandatory minimum where I thought the defendant should not have been sentenced that way. This was the girlfriend of a drug dealer who was forced to carry a package, and when she was picked up, she had a package that contained a large amount of drugs. She was subject to a mandatory minimum.
Interesting. All right, let's move on, if we can, to a decision today in federal court here in New York. A judge has appointed an outside set of eyes to oversee changes to NYPD's stop and frisk program. She said that the program as it now exists infringes on the 4th and the 14th Amendments. Basically, she said, and I'm putting it in layman's terms, that too many minorities were being stopped under this program, even though the police claim in defending this suit, and the city claims that the minority communities are the high crime areas. Minorities themselves commit a hugely disproportionate amount of the crimes, and that the murder rates and the crime rates have dropped not only citywide but in these minority communities. So how do you see today's decision?
Well, I think today's decision was probably expected, but is really unfortunate. In fact, I looked through it. It's 180 some
yeah,
odd
it's
pages.
a long one.
It's a long one. But this judge has taken on herself the authority to essentially regulate the New York City Police Department, to put in place a monitor, to require that the police department have a pilot program of body cameras in which police would carry cameras on their bodies. And it's based entirely on statistics, when what the law requires is an intent to discriminate. And, Benjamin Disraeli is famous for having said many things, but one of the things he said that couldn't be truer is that there are 3 categories of falsehood. There's lies, damned lies, and statistics are the worst of all. And this decision is based entirely on statistics.
And would you go so far as to say that, this just reinforces, to me, the blind redefining of racial profiling as something evil. Profiling is something police do on various levels. Racial profiling, the bad thing that they refer to is what happened on the Jersey Turnpike when cops were stopping blacks for no reason and harassing them. I don't call that racial profiling. I call that harassment.
Or when they were just stopping black speeders but not white speeders. I mean, that's
right. That's awful.
Right. That's horrible. That is blatant discrimination, and that should not happen. But when a police department draws a profile, just as, for example, the Israeli intelligence people the people who screen people at airports draw a profile of what a terrorist is likely to look like, and they don't wind up searching little old ladies with walkers. This is the same thing.
Do you think that this on appeal will be overturned, make it to the Supreme Court eventually, or what?
I don't know about the Supreme Court. If I had to bet, I would certainly bet that it's going to be overturned. I think this is going to have the durability of one of those $3 umbrellas that you buy in New York, and they collapse as soon as the wind kicks up.
Judge, it's always a pleasure and an honor to speak to you. Thank you for taking the time.
Thanks for having me.
Bye-bye.